The state has told the SCA that the whole Nulane agreement was a fraud as Nulane did not do any work. It argued that in the documents, the Department of Agriculture states that Nulane was the only company that could do the feasibility study for the Mohoma Mobung project. However, Nulane appointed a subcontractor to do the work. The subcontractor was only paid 1.5 million of the 24.9 million rent paid to Nulane, while the other amounts were then paid to other accounts, including the Gupta-linked island side.
By that time, they've done nothing. No commercial rationale, pure theft in terms of the regulatory framework. That's common cause. It was common cause. If you had an experienced judge, and I would submit a matter like this, you give it to your most experienced criminal judge. Experienced judge would have said, but what are we fighting about? I'm just here why you guys did this.
Respondents call for the state's application to be dismissed, premised on highlighting the lack of evidence on the state's case. Advocate Thabethe Ngubeni called the state's appeal an attempt to reinvent Nulane case by trapping the court into arguing the case on merits.
The facts upon which the trial court based its findings. The facts are clear. If the court falls into that trap, then this court is rendered a court of first instance.
The defense also argued that the state failed to prove its case, and it is attempting to ask the SCA to do what it doesn't have the power to do.
The applicant has failed to prove its case against the second respondent beyond a reasonable doubt.
The respondents also argued that the state case suffered fundamental defects, emphasizing that there's vacuum in the state's case. It argued that the SCA should not lose sight of the burden of truth that lies with the state.
So Zula's evidence on that score fell short of convincing the court of the truthfulness and the reliability and accuracy of his evidence.
Dinesh Patel told the SCA that he couldn't have known about the fraud that was allegedly purported.
Justices, those contracts are not before court. Because the admissibility factor was never touched on by the state had the prospect of going to a trial within a trial to prove the admissibility of those documents, which remain copies. And what's even more damning of Mr. Mtolo's evidence was that it became clear, demonstrably so, that it wasn't certain where those documents emanated from.
But there is no fraud, there's no evidence led to suggest that the Company Island site, or for that matter, Ronica Raghavan, participated in any way.
Judgment has been reserved. Makhala Masiteng, SABC News, Bloemfontein.